This is Mary Hart with the Alternative Investing Movement, or AIM for short, and I am here today to give you part one of why everyone over the age of 18 needs an estate plan. We're going to talk today about disability planning, what you need to put in place to plan for a potential eventual disability, whether it's a temporary disability or a permanent disability. And I know that you may be thinking, I don't need an estate plan, I'm not rich, I'm young, I'm healthy, none of this is going to apply to me. But I am here to tell you that that is simply not true, and it will be worth your time to listen for just about 8 to 10 minutes about disability planning and how to make sure that your wishes are fulfilled and that you get to take control in the event that something were to happen to you. Now, this might not happen to you when you're young, it might not happen till the end of life, but probably close to 40 to 50% of Americans need some sort of intervention because of a disability at some point in time during their life. So this could be you, and it's extremely important topic, so I hope that you take a few minutes to sit down and listen to basically disability planning through estate planning documents. So they're really about 5 documents that are the foundation of our disability planning documents. We call these Advance Directives because you are directing in advance what you want to happen in the event that you become disabled. Again, whether that's temporarily or permanently. Let's say you're in a car accident and you're in a coma for a week and then you wake up and you're fine. Somebody still has to make decisions for you in your health care and maybe other decisions for you besides health care. During that week, you're in a coma. Let's say, God forbid, that you're in an accident and you're in a coma for the rest of your life. Or you're older and you get Alzheimer's or dementia and you can no longer make your decisions. Someone will have to make those decisions for you. We want to go ahead and put these advance directive documents in place so that we don't have to go to court and get someone appointed as your guardian or conservator. That process is a very long, tedious court process. It is a lawsuit, basically a legal process where you go to court or someone goes on your behalf and ask that you be found incapacitated and that they be appointed as your guardian or conservator, that they're the right person to serve in that job. And if you get to that point, you've lost all control over who makes decisions for you if you become incapacitated. So these advance directives are very important because they let you specify in advance who is going to make decisions for you and set some parameters around those decisions in the event that you can no longer make decisions for yourself. Again, temporarily or permanently. So what are these advance directive documents for disability? The first one is your healthcare power of attorney. Who will make your healthcare decisions for you if you are unable to make them yourself? You can appoint one person or multiple people. If you choose multiple people, you can have it so any one of them can make a decision for you at any time, or they all have to consent. Keep in mind, however, if you name multiple people and they all have to consent, that this could really jam up your healthcare decisions. If we've got to get multiple people together and get them all to agree, then your healthcare decisions may not be able to be made quickly enough. So give serious consideration to whether you want that to be your decisions to be made by one person or multiple people. If you do name one or multiples, make sure you put successors in there. If the one person you've named cannot act, who jumps in their place as the successor agent to make your healthcare decisions? Give careful consideration to who you actually name to make these decisions for you. Geographical distance away from you is a concern, but it's not as big of a concern as finding someone who will be responsible, who will make decisions in your best interest and in the way you think you would make the decisions yourself. So find someone that has your best interests at heart, that you trust to be responsible and to make appropriate decisions. Otherwise, the geography is less important. It's less important. Now, if you can have someone right in your local area that's also responsible and will act in your best interest, that's great. But if not, worry more about the responsible person than where that person is located. So we've got your healthcare power of attorney. That person does not kick in as your healthcare agent unless and until you're not able to make decisions yourself. So as long as you can make your healthcare decisions, you will make them. But if at any point you can't make them yourself, then this document has named that person who has the authority to act for you once you are declared incapacitated by your doctor. So that's the healthcare power of attorney. You may also want what we call the living will. It's also known as a declaration of a desire for a natural death, and some people crudely nickname it the pull the plug document. That is the document that specifies your wishes, that you would not want to be kept alive by means of artificial life support if that is all that's keeping you alive. If you have an irreversible medical condition that will otherwise cause your death within a relatively short period of time, the living will is the document that sets forth your wishes that you not be kept alive by artificial life support. So once it looks like that is all that's keeping you alive, this document allows your healthcare agent to ask the doctor or the hospital to terminate your life support or pull the plug. It is a very important document if you do not want to be kept alive artificially, because without it, your healthcare agent does not legally have the power to mandate that your artificial life support be terminated. Now, they may find a doctor or a hospital that will terminate life support regardless, but if not, then this living will document is the sword that your healthcare agent can use to enforce your wishes. So whether or not you do a living will, sign a living will, is a very personal decision, but if you would not want to be kept alive artificially, it is a critical document to have in your arsenal. The third document I want to talk to you about in the healthcare realm is the HIPAA Waiver. You may not have heard of the term Health Insurance Portability and Accountability Act, but I'm sure you know the result of it, because every time you go to a doctor's office and have to sign your notice that you understand that your medical records are private, your right to privacy, that is a direct result of the HIPAA, Health Insurance Portability and Accountability Act. So that's great. We want our medical records to be private, except what if our healthcare agents need to get access to medical information to be able to make an informed decision about your healthcare? We want to make sure those agents have the power to get your medical information. So we often recommend that you sign a HIPAA waiver, waiving the privacy right for those persons you have named as your healthcare agents. That way we know that they won't run into that roadblock. They'll be able to get your medical information and make an informed decision about your healthcare. The fourth document you may or may not need. It is called a hospital visit authorization form. In most states, you have a patient bill of rights that says that you have the right to dictate who can visit you when you are a patient in a hospital or other medical setting. That certainly works as long as you're conscious and able to communicate your decisions. But in some cases, if you become unable to communicate your wishes because you're unconscious or incapacitated in some way, the hospitals will limit visitors to only your blood relatives. That doesn't happen across the board, but it happens enough that if you have people in your life that are not related to you by blood, that you would want to visit you in the hospital, you might want to sign this hospital visit authorization form, specifically granting them the authority to visit you in a medical setting like a hospital. For instance, I have done this for my stepchildren. It's my hope that the hospital or doctor would let them in to see me, but I can't guarantee that. So I have signed a hospital visit authorization form granting my stepchildren the same rights as my blood children, biological children, to get into the hospital to visit me. Now let's just hope they want to. I think they will. We have a pretty good relationship. But that is an important document to me. It may or may not be important to you. But if you have a friend or a non-blood related person that you want to visit you, it's an easy document to create and sign, and you ought to think about it. So those are the 4 healthcare advance directives. But what about all those decisions you need to make every day that are not related to healthcare? Think about everything you have to think about and decide from the moment you put your feet on the floor when you wake up till the moment you go to sleep at night. Who pays your bills? Who maintains your insurance on your properties? Who hires somebody to take care of things? Who hires a housekeeper? All the decisions you make all day long, all your business decisions. Who deals with Facebook and all these things? Well, if you can't make those decisions yourself, then someone has to make them for you. And you can either sign this document, it's called a durable power of attorney, Or if you don't have that document, then once again, we're in the realm of someone going to court to be appointed as your guardian or conservator. The language depends on the state you're in. But that is a time-consuming, costly, stressful process. So rather than go through that, it behooves us all to sign a power of attorney document appointing one or more persons to make your non-healthcare related decisions if you are unable to make them yourself. And you can make that a document effective either the moment you sign it or only if you become disabled. And there are pros and cons both ways. I've made mine effective the moment I signed it because what if I'm traveling? I'm using my money to travel to Europe and I don't want to deal with the insurance agent at the time. Then my power of attorney, my attorney in fact, can make that decision for me. You may want to make it effective only if you are declared disabled, but again, nobody can then make your decisions until probably 2 physicians have examined you and declared you to be incapacitated. But that durable power of attorney is the document where you can appoint one or more persons to make your non-healthcare decisions. And all those same sort of issues come into play when you're choosing one or multiple agents, just like we talked about the healthcare power of attorney. There's one important point that I want to make with this document. This document needs to have specific language in it that makes it durable, that makes it endure a subsequent disability or incapacity after you've signed it. For instance, the sentence would read something like, "This power of attorney shall remain effective in the event of my subsequent disability. This power of attorney shall remain effective in the event of my subsequent disability, my subsequent incapacity," something like that. Because without that language, then this power of attorney document that you have put in place will be revoked by operation of law the moment you become incapacitated. Well, that seems a little silly because that's when we need the power of attorney most, right? So I highly recommend that if you're doing this yourself, or you're doing it on an online software, or you're picking up an old style form in a stationery store, does anybody do that anymore? Anyway, that you make sure that your power of attorney is a durable power of attorney and that it has that sentence in the document somewhere that says it endures a subsequent disability. So that's very important. You can choose to have your durable power of attorney be as narrow or as broad as you want it in terms of the powers, and I recommend that you consult an attorney in your state before you do these documents. But I just wanted to let you know what the initial foundational disability planning documents are. So we've got the healthcare power of attorney, the living will, the HIPAA waiver, the hospital visit authorization form, and the durable power of attorney. That's all we're going to discuss here in part 1 because I know you're busy, but we will come back with part 2 and talk about planning for death and another type of disability planning using trusts. So have a great day, and if you have any questions, feel free to check us out at thealternativeinvestingmovement.com, or you can email me at maryhart@alternativeinvestingmovement.com. Have a great day.